Hello friends, in the series on the income tax cases, today we will discuss the case of Kone Elevator India Private Limited versus Assistant Commissioner of Income Tax. This case has been reported in 450 ITR, page number 338. The matter has been decided by Madras High Court and the date of the judgment is 1st September 2022. Friends, this is a very unique case and this is a perfect example that how much arbitrary powers have been given to the income tax officers, and at present there are no certainty to the assessment proceedings which have been concluded for an assessee, because the assessee can be sent the notice under section 148 for the 10 years. There are complete chances of section 263 proceedings by the Commissioner of Income Tax for revision, and the orders which are coming from the various courts shows that in very rarest of the rare cases now the relief is being given to the assessee, and these proceedings, whether in the form of section 148 or 263, are turned valid in maximum number of cases. This is also a very unique case. In this case, there were transfer pricing transactions. The transfer pricing officer suggested an upward revision of 25.73 crore and the assessing officer issued draft assessment order to the assessee. The rule is that the assessee has to counter this draft assessment order within 30 days. But in the present case, the assessee did not object to this draft assessment order. And a very unique thing happened in this case, that even the assessing officer did not pass the assessment order within the limitation period. The limitation period gone, the limitation period expired, and there was no final assessment order passed by the learned assessing officer. When the department realized this thing, the department found that there is one arm with the department in the form of section 148, and the department issued on the same grounds which were suggested for the upward revision in the proposal by the transfer pricing officer, and section 148 notice was issued. When assessee received this notice under section 148, the assessee was of the opinion that this notice has been issued just because of the failure of the assessing officer for not passing the assessment order in time, and it was just to complete his inefficiency, his inability to pass the assessment order. And this point of the assessee was very much valid, because the grounds of issuing the notice under section 148 were the same which were suggested by the transfer pricing officer. So the assessee challenged this section 148 notice into the writ court. When this writ came for hearing, the court said that there is no illegality in issuing the notice under section 148, because section 147 read with section 148 is very clear. When there is escapement of income, when there is a proper and pure facts that the income has escaped assessment and the assessing officer has in his knowledge the information that the income has escaped, then he can issue the notice under section 148. Because in this case the department was knowing that the income has escaped, but that part was not considered by the court, that it was totally an inefficiency, inability and lapse on the part of the assessing officer to pass the assessment order in the limitation period. If this type of things will be allowed, the assessing officer will not pass the assessment order and then he will issue the notice under section 148. Because if the assessment order is passed, then he has to work a little bit harder. But if he will not pass the assessment order, then it will be very easy for him relying on the judgment of this case. So with due respect to the Madras High Court. This decision is very harsh according to me, but in this case the notice under section 148 was held valid. At the end of this video, once again I am repeating the name of the case. The name of the case is Kone Elevator India Private Limited versus Assistant Commissioner of Income Tax, and this case has been reported in 450 ITR at page number 338. The matter has been decided by Madras High Court and the date of the judgment is 1 September 2022. Thank you, friends.